if I may use the word, mandatory contents of a contract. Typically over a period of time, contracts tend to become very complex, and the more number of clauses, the more difficult it becomes. Quite a few to begin with. So importantly, one has to ensure that what is, when you're signing into a contract, your exposure in case of a breach. Sooner you challenge it, better it may be, at least for you to possibly handle the legal situation.
Hello Galatta Ritz viewers. So today we have Mr. Anant Merathia with us to talk on banking, finance and law. Hello sir. Vanakkam.
Hello sir. Hello. Vanakkam.
So today we are going to talk about something which is really important for the customers and the consumers when they are signing a contract, or when it comes to banking, law, all three aspects were like how I introduced in the introduction. To start with, what are all the key factors when a consumer or a customer signs a contract should definitely look into it?
So contract signing has become part of our day-to-day life. We don't even realize that. Of course, starting from signing online where we just write I agree and we just agree to what it is. But from a practical perspective, I would look at this in about 2 or 3 perspectives. Number one, when you're signing a contract with a larger institution on the other side, it could be a financial institution, a lender, or a corporate, or a big company, or let's say an insurance company, you frankly don't have too much to you don't have much of a chance to negotiate, even if the terms are one-sided. But having said that, as a consumer, as a customer, you should definitely go through all the terms of the contract, which will at least give you a fair idea that what are your obligations in case tomorrow there are going to be unexpected situations or some challenges or difficulties. What is going to be your exposure? So therefore, that's something which is important. It also helps the customer know what are the obligations of the company with which it is entering into a contract, which people tend to generally not realize. So this is with larger corporations. And when the contracts are being between two sets of individual companies or two individuals or two SMEs on a one-on-one business contracts, those are even more important. They should certainly be gone through, because that's where a lot of disputes, when they arise, there should be clarity as to how it's going to be handled. If I may use the word, mandatory contents of a contract. Typically over a period of time, contracts tend to become very complex, and the more number of clauses, the more difficult it becomes. Some basic content should be, at least the parties who are signing or getting into the contract, their basic introduction, name, address, details, their identification document or whatever it is, followed by what is the purpose of the contract. We call it the recitals. But the contract is for so and so, and this is the basic purpose. And then what are the obligations of both the parties? Party A, obligations, party B, obligations. What happens in case there is a breach in either of the obligations? That's very important. What would be the term of the contract, and will the breach lead into a termination, and how does that process work? These are the broad level important aspects. One very important aspect in the contract is the dispute resolution clause, where people tend to just put in, either it's left a little vague, or you have courts to be deciding the disputes, or sometimes there's an arbitration in a fancy place which may not justify the value of the contract itself. So yeah, that's another one important aspect. Of course, there are what we call a lot of clauses that come into a contract towards the later part of it. We call them boilerplates, standard clauses. So they may not have too much of a immediate relevance, but at the same time they have their own importance. But these what I've mentioned are important, and it has to be ensured that the contracts are signed by both the parties. Ideally, there should be witnesses. Both the parties should retain counterparts of the contract. Original copy should be there.
Along with a lot of scams which are happening in the country. So we see people mentioning without any background, or without any verification, or without any identity towards having a legal perspective or a legal consultant. They say, if so and so has been mentioned, if so and so has been done, you will be brought to the court. Without any consultation from a legal perspective, can a individual person draft a contract saying, if you are so and so, if you don't follow on these categories, if you don't find any proper ways to finish this contract within this time period, I'll bring you to the court. Is that possible, sir?
It is possible. If you ask me practically, is it possible? Yes, people do, especially because let's talk about startups. Now startups, smaller companies, they do not have the financial bandwidth, nor do they have access to professionals who can draft out a professional contract for them. So they tend to draft such contracts. But then in that case, they should have some basic idea that these mandatory requirements should come into the contract. And it's not that a contract drafted by two sets of private parties directly between themselves without involving professionals, that will not have legal validity or sanctity. It will have, but then equal number of loopholes could be there. So it is better that at the very early stages on whether it's your professional business career or even if it's a startup, If people can start getting professional advice, it's certainly better.
So what are all the loopholes, sir? Like how you mentioned, there are certain loopholes. What could be the possible loopholes?
Quite a few to begin with. So importantly, one has to ensure that what is when you're signing into a contract, your exposure in case of a breach. So if it's suppose knowingly or unknowingly you're not able to fulfill your commitment towards whatever you've committed in the contract, does that merely mean that the contract is terminated, or does it also mean that you will have to give a huge amount of compensation? We call it indemnity, or as the case may be. So that's something which is something most of the businesses tend to oversee. Similarly, dispute resolution clauses that we have seen somehow don't tend to incorporate what is, I feel, really the need of the hour in this country is alternative disputes mechanism, especially mediation. In fact, the contracts that we normally draft, we advise our clients and especially companies that let's have a mediation clause. Mediation is something where you have now a trained mediator who will follow a certain procedure and try to get the parties to come at a mutually agreeable solution, helping them in a big way to avoid the whole litigation system. There can be a time-bound mediation within 15 days, within 30 days or whatever. If that fails, the matter can go into either arbitration, which is a slightly more, I would say, legal process, or the courts. So that's one tricky area where people can be careful. And now there are options of online mediations, online arbitration. So these are all cost-saving factors as well. So these are at least few things which I won't call them loopholes per se, but specifically people will have to look out for these.
So when it comes to documents, when it comes to contract, there are people who say just sign it in the paper, or just give your stamp on the paper, just on an A4 sheet, without drafting anything, without writing anything. Just because people are illiterate or uneducated, for a fact they tend to exploit in such a way, is what I have heard. So signing in an empty paper or an empty document or an empty stamp paper, how dangerous it could lead to?
You're talking about people being illiterate and people who are not very exposed to the commercial world doing it. About my 19 years of experience in cases of shareholder disputes, company law board, and now the National Company Law Tribunal, commercial disputes, we have seen in so many closely held companies, family held companies, companies started by relatives, by friends, where blank signed papers have been misused to a fair extent. Now, typically, just to give you a few examples, in some good faith, let's say there are some blank papers that you have signed, A4 sheets of papers, you've signed and given it to your partner, your trusted, whatever aid, or so be the case. Now, that person can always mention that you are resigning from the company, you are relinquishing your rights in the company where you are a partner, you are relinquishing your shares in that particular company, or you don't have anything to do with that company. So that is on the commercial side. Similarly, at a personal level, that blank paper can always be used to be say, okay, this is a will. A will need not necessarily be on a stamp paper, and then somebody can come and sign it, and that's where all these disputes end up happening. It can also be misused for power of attorneys. So signing on blank papers is something which should be, I would say, it should be as good as made illegal. That's a process we cannot afford to now follow anymore. And how much ever be the good faith situation, it should become like a personal, I would say, personal constitution or a personal parameter for every person saying that no, blank piece of paper I will not sign, even if it's a bit of inconvenience, logistics, the person has to come and sign somewhere. Or in that case, you do one thing, give specific power of attorney to a person who you trust, saying, okay, I'm giving you a specific power of attorney to possibly dispose this piece of asset or to do the necessary whatever action has to be taken. But blank paper signing has always been a cause of, at some point in time, misuse or litigation.
If at all, suppose if in case I have signed a blank paper, so and so some other person has utilized my name and utilized my signature to take away my will or shares or whatever it is. What if I come and claim this as a case in the court? So how does this proceed?
It's going to be difficult.
Very
it's going to be complex.
Okay.
The challenge, I'll tell you why. See, when you go and tell the court that you signed blank paper in good faith, typically courts, I mean, it's going to be difficult to convince the court. The matter will go in trial and the matter will get delayed. Even if, let's say for a minute, if you're trying to challenge saying it's not my signature, typically courts will send it for forensic checks. Forensic checks will show that it was actually your signature. So unless you're in a position to very clearly establish that you had signed that blank paper in coercion, under certain pressure, with a, let's say, a gun on your neck, it was a situation like that, and the sooner you challenge it, the better it may be, at least for you to possibly handle the legal situation. But after 5 years, 8 years, 10 years going and saying, no, I did this and this person misused it, possibly took a loan in my name, did so and so, so and so. That's something, as they say, the law, there's a concept in law, you can't sleep over your rights. So you need to know what your rights are and to take appropriate action that has to be taken.